that the M word is a constitutional mandate, that the M word is part of the constitutionally protected package. Why? Because of what it signals about the importance of giving dignity and respect to all human beings, regardless of their sexual orientation. But there's an irony there, to say the least, and I will end up with that, because what the court actually ends up saying is that these core substantive rights that they're about to protect include, most fundamentally, the opportunity of an individual to establish with the person with whom the individual has chosen to share his or her life, picking up on Perez, as well as resonating back to Hannah Arendt, whom no member of the California Supreme Court had ever heard of, an officially recognized and protected family relationship. An officially recognized and protected family. That's about as high a notch up as you could get as a kind of generalized statement of what this fundamental right is about. Possessing mutual rights and responsibilities and entitled to the same respect and dignity accorded a union traditionally designated as a marriage. And what the California Supreme Court actually does is to suggest that if the state erased the M word and instead provided another word for everyone, as long as it was open on the same terms to everyone, for this officially recognized family relationship, etc., call it marriage times 9, or marriage minus, or civil union, or domestic, or marriage plus. Why not plus? Marriage multiplied. Non-marriage better than ever, or something. That as long as everyone could participate, that would be fine. I mean, there's this remarkable suggestion from a Republican conservative majority of the California Supreme Court that maybe our problem in America is with the M word, and that we should be thinking of ways of protecting mutually supportive relationships of all kinds that are not sort of trapped, perhaps, within the marital institution. I mean, who knows? Because soon thereafter, 18,000 couples get legally married between June and the election. I have pictures of a lot of them. The first to get married were the 50-year folks, Phyllis and Dell. Here's what some people who had been in a civil commitment ceremony here on this campus, and then on their anniversary 4 years later went and got married. They already had a child. Here are some folks in LA. Now, remember, I mean, what I've been saying, too, about the narrative and the presentation. We've got the, joyous couples. Here are some of my favorites. This is John and Stuart, not John Stewart. Why are they my favorites? Because Stuart's on the left. Stuart's parents met here at International House during the Second World War. And they fell in love, but they couldn't get married. His mixed race, and I'm sort of forgetting it's a multi-mixture, Japanese, African American, Hispanic, Caucasian. But pre-Perez, they couldn't get married here in California. They waited out until after the war, and they went to New York, and they got married there, and then eventually came back here to California. So here he is, eager to marry his very long-term partner, John Lewis. And John turns out to be in the family law class that I taught at Stanford Law School in the winter of 1984, which he remembered, but I did not. in which he swears that we had a discussion about whether there was any state interest in excluding homosexuals from participating in the marriage relationship. I said, so what was the outcome of this discussion, John? And he said that the whole class agreed in 1984 that it would never happen. That is, that nothing like this would ever come about, but that there would come a time where there'd be an intense argument about whether the states could justify exclusions of people. But then, I mean, no sooner are people happily married, and this couple having the now almost mandatory twins as a result of assisted reproductive technology, we get Proposition 8, right? And Proposition 8 takes away the M word. That's really what it does. And then the California Supreme Court has to answer the question whether under California law, we the people can take away a constitutional right that has been recognized here. And the California Supreme Court goes through contortions, and in an opinion called Strauss versus Horton, decides that Californians can do this. We may not like it, but we are committed to this referendum and initiative process, and even though it's a constitutional amendment, and it does overrule a major piece of the marriage cases, somehow Californians can do this. But how does the California Supreme Court deal with the fact that so much of its opinion in the marriage cases is about this constitutional right to the M word? What is this recognized and protected family relationship if you can't use the M word? And they really have to tie themselves in knots. And ultimately, what they say is, well, sort of, gee, we're really sorry, but California does provide all these protections through domestic partnership. Sorry. And it's a really sad sort of opinion. But then come the dream team, right? And it's 2:00. Our odd couple, Boys and Olson. Is it to the rescue, or is it to some disaster? I don't know. No one knows. The case is sort of stalled. Here, the good-looking part of the narrative, plaintiff, live in Berkeley, raising 4 children. The southern wing, the Los Angeles, Hollywood guys, want to get married, want to have a family. You read their testimony, and if you read any part of the account of Helen Zia's testimony that I posted on your B-Space site, Chinese-American woman married to a Hawaiian-Japanese woman. They'd lived together for 17 years and so on. And this sort of narrative of it's the M word that really matters. And then sort of onward. And what I didn't do today, so I can come back again sometime, Tom, is talk about what the opposition says, which is that that's the next time. Right.